The respondent, dependent.
Yes, just a moment, please.
Yes, ma'am.
Yes, so the court will proceed to deliver the judgments. This is an action commenced at the instance of the claimants via the complaint dated and filed 23rd day of April 2019, with accompanying processes upon which they sought the following reliefs against the defendants in the manner set hereunder. 1, a mandatory order directing defendants to forthwith pay each claimant as follows. 1, sum of 1,282,628 being the 45% of the annual basic salary as accommodation allowance for 3 years. 2, sum of 1,350,285 being the outstanding balance of furniture allowance of 300% of the annual basic salary, and which is 2,850,285, thereby removing 1,500,000, which has already been paid to each of the claimants, as part payment of the said furniture allowance. 3, the sum of 2,850,285 being the 300% of their annual basic salary as severance gratuity due to them as local government legislature in Zamfara State between 25th July 2012 to 24th December 2015, when their tenure expired. Then 3B, alternatively, a mandatory order directing defendants to forthwith pay each claimant the total sum of 5,483,196 as their entitlement due to each of them for serving Zamfara State government between 25th July 2012 to 24th December 2015. In the alternative, the sum of 268,676,604 being the accommodation allowance, remaining balance of furniture allowance, and severance gratuity due to the claimants as local government legislature representing different wards from various local government councils in Zamfara State from 25th July 2012 to 24th July 2015. Then cost of action. Upon service of the complaint on defendants, they filed their memo of conditional appearance 10th May 2019, alongside the counter affidavit and written address to the motion for summary judgment and a joint statement of defense. When matter came up for consideration on 13 June 2019, claimants counsel withdrew motion for summary judgment and same was accordingly struck out. In the course of trial, claimants opened their case on 22nd January 2020, called 3 witnesses and tendered several documents marked as Exhibit CWT1 to 50, AL1, B1, and B2. Claimants closed their case 18th March 2022. Defendants on their part did not file any witness statements or notes in support of their statements of defense and were not even ready to proceed with their defense on the day scheduled. The application of claimants' counsel on the day scheduled, and so the application of claimants' counsel to foreclose them was granted on 19th May 2022. Consequently, by motion filed 21st November 2022, claimants sought to regularize their final written address, which is dated and filed same date. In response, defendants filed final written address dated 23rd November 2022 and filed 25th November 2022, to which claimants filed a reply address dated and filed 9th February 2023. Thereafter, parties adopted final written addresses 9th February 2023 and matter adjourned for judgment. Claimants, the case of the claimants is that they were all the elected councillors of various wards in Zamfara State and served in such capacities between period of 2012 and 15. that after expiration of their tenure, they were all entitled to accommodation allowances, furniture, and severance gratuities, pursuant to the reports of Revenue Mobilization and Fiscal Commission, which they claim was adopted by the first defendant by circular of 16 March 2007. The reference number is quoted herein. However, that the defendants only made part payment of 1,500,000 for furniture allowance, while the other claims remained completely unpaid, despite letters of demand issued to the defendants, hence the action against them. In the claimant's final written address of 16 November 2022, which was filed 21st November 2022, counsel formulated two issues, thus, whether claimants have established the existence of their right to entitlements to warrant this court to rule in their favor, and two, whether by the requirements of the law and standard of proof, the claimants prove their case with the standard of proof. Claimants' counsel submission. On the first issue, counsel restated the established principle of law that he who asserts must prove. It was posited that by the various exhibits in the suit, claimants have established their legal right against defendants. Equally, that the tried principle of law, which places the burden of proof on the claimants by way of evidence, was given judicial backing in the case of Onemu and Commerce, Agric, and Natural Resources, Asaba. The citation is provided herein. Counsel here reiterated that the claimants have tendered an array of evidence, including their affidavits and certificates of return of their respective elected offices, to establish their legal rights. Furthermore, defendants have not been able to discredit the evidence. Thus, the claimants are entitled to the remedy they seek from the defendants. On the second issue, counsel argued that by reason of the law, which puts the standard of proof in civil proceedings to be based on the preponderance of evidence, that claimants have proved their case as required by Section 134 Evidence Act 2011 as amended, which he urged the court to so hold. Now, defendant's case. Defendant's case is hinged on the assertion that he did not issue any circular as claimed by the claimants and are neither owing them any of the sums claimed, as they had been paid all their entitlements before the expiration of their tenure. In their final written address filed on 25th November 2022, two issues were distinct for the resolution of the court as follows. One, regard being had that exhibits AL1 being a public document and not certified true copy, whether it is right for the Honorable Court to act on it and grant the relief sought by the claimants. Two, whether or not regard being had to the testimonies of PW1, P2, and 3 made out a case against defendant to warrant the court to enter judgment in favor of all 49 claimants as per the relief sought. Arguing on the first issue, counsel urged the court to resolve same in their favor by relying on Section 105 Evidence Act 2011 to the effect that only the documents which are certified in accordance with 104 section of Evidence Act may be produced in proof of content of public documents. Also, that the law is settled that the only piece of secondary evidence of a public document which is admissible is a certified true copy and no other, relying on case of Emeka and Ikpeazu, that exhibits AL1 not being a certified true copy cannot be produced in proof of the contents of a public document, and he urged the court to expel same from its records. Counsel to defendants started with the second issue by relying on Section 136 sub 1 Evidence Act 2011, which establishes the principle of evidential value, body. He also stated the well-established principle guiding standard of proof and burden of proof in civil cases. He referred the court to the case of Amadi and Amadi. He posited that the evidence of CW1, particularly paragraphs 9, 10, 12 to 16 of statements on oath of 23rd April 2019 are at variance with paragraphs 9, 11, and 13 of statements of facts, and that evidence at variance with a party's pleadings or not covered by pleadings go to no issue, urging court to so hold in claimant's favor, and urging court to so hold, citing Yahaya and Dankwambo. Regarding evidence of Ashiru Isiaku, that's PW2, counsel contends that it is hearsay evidence. That's the defendant's counsel contending that it is hearsay evidence, as he submitted that the witness had admitted that his written statement or note was based on what he was told by their union. To buttress his argument on this point, he relied on Section 37 of the Evidence Act 2011 and the case of Akereke and Umahi to defend that hearsay evidence is inadmissible and lacks probative value, more so that the union from which CW2 got his information never came to court to testify of the truth or otherwise of what he stated. Hence, that the court should expunge his testimony. For PW3, counsel in his contention here adopted his submissions regarding PW1. On the whole, defendant's counsel urged the court to resolve the two issues in favor of defendants and dismiss claimant's case. Now, claimant's counsel filed a reply address in reacting to defendant's issue 1 on the admissibility of exhibits AL1 and posited that defendant's counsel cannot be objecting to admissibility of such exhibits at this stage, having failed to challenge same earlier. Also, that counsel, that defendants being the custodian of the document, did not challenge its existence. He does urge the court to do substantial justice rather than align technicalities to prevail. He continued that this court, in the case of Honorable Kabiru, Sahabi, Liman, and 2 others, versus Zamfara State Government and another, in suit number NICN/KN/42/2016, strongly relied on this document and gave judgment in favor of claimants in 2017. In reacting to defendant's second issue, claimant's counsel restated the principles of law relied upon by the defendants and submitted that having failed to supply the courts with the particulars of contradictions claimed, counsel's argument goes to no issue, and court should disregard same and give judgment in favor of the claimants. Now, decision of the court. I find it apt to state that matter commenced briefly before my learned brother, Honorable Justice K.D. Damulak, on 13 June 2019, which commenced de novo on 1st November 2019. However, it had suffered some delays by reason of the COVID-19 pandemic lockdown, as well as the judicial strike that took place from April to June 2020. The summary of this case, as contained in written depositions of witnesses and evidence before me, is that the claimants were elected councillors of the different wards in Zamfara State between 2012 and 2015, when their tenure expired. That they were, in addition to their salaries, entitled to other fringe benefits, which includes accommodation allowances, furniture allowances, and severance gratuities, which they claim remain unpaid by defendants, forming the basis of their action in court, while defendants have made general denials in their pleadings against owing the claimants. Flowing from the issues submitted by the parties, this court distills a sole issue for determination thus: whether claimants have proved their case on the balance of probability to entitle them to the reliefs claimed. Before I delve into the substance of the case, I shall first of all make a determination on defendant's counsel issue 1, which to my mind qualifies as a preliminary issue. The crux of the argument therein is that Exhibit AL1, being a public document, was not properly certified as required under Section 104 and 105 of the Evidence Act 2011 and should thus be expunged, while claimant's counsel opposed that line of submission, urging court to do substantial justice and that defendants cannot raise such arguments at this point in time. I have had reason to go over the record of proceedings of this court, and particularly that of 18th March 2020, during which the said Exhibit AL1 was tendered by claimant's counsel and its admissibility objected to by defendant's counsel, to which this court gave its ruling. Thus, bringing up the same issue again at the stage of final written addresses only amounts to asking this court to sit on appeal over a ruling it had already delivered, which is contrary to the settled principle of law as held in the cases of Iteogu and LPDC 2018-11 Nigerian Weekly Law Report, Part 1630, 375 and 387, Paragraph D, and the case of Williams and Adult Sam Nigeria Limited, 2022, 5 Nigerian Weekly Law Report, Part 1822 and 23. Consequently, the said issue is resolved against the defendant. More so, this is not a case of wrongly admitted document which can be expunged in the course of judgment, as decided in Haruna and Kogi State House of Assembly, 2010, 7 NWLR, Part 1194, 604 at 637 to 636, to 637. Moving on to the merits of the case. It is pertinent to state, as already submitted by both parties, that in civil proceedings, the burden of proving a case lies on the party who will fail if no evidence is adduced on either side, and the standard required to establish such claim is on the preponderance of evidence. See Ogbonna and Ogbonna, 2014, LPLR 22308, Court of Appeal, paragraphs B to C. In order to prove that there has been any breach of any term or condition of service, it is the party alleging that has the burden to place such document or documents before the court, and then show in what manner the breach was committed. Also, in order to determine which document contains the terms and conditions of service, the surrounding circumstances and facts must be considered, as in Ladipo and Chevron Nigeria Limited, 2005, 1 NWLR Part 907, 277 at 289. The claimants have, in proof of their claims, tendered their return certificates of election into the Office of Councillors, see Exhibit CWT1 to CWT49, which shows that they were elected into office on 23rd June 2012. Also is the pre-action notice written by Claimant's Counsel and addressed to the third defendant, which was received on 20th December 2018. Exhibit AL1, which is the revised remuneration package for political, public, judicial office holders in Zamfara State, stipulating various financial entitlements as applicable to the category of the claimants. The said Exhibit AL1 was made effective from 1st February 2007, as signed by the Secretary to the State Government. Now, Claimant's Counsel had made reference to pages 5 and 6 of Exhibit AL1 in their witness statements on oath, which I have carefully perused and noted that it corresponds with the monetary claims for furniture allowance and severance gratuity, which is to be paid at the end of each tenure, while for accommodation it is to be paid annually. It is also in evidence that claimants had admitted to being paid part of their furniture allowance in the sum of 1,500,000, leaving an outstanding balance of 1,350,285, as contained at paragraphs 12 and 13 of the witness statements on oath of CW1, CW2, and CW3, which were not challenged or contradicted by the defendants, who had the onus of now proving by credible evidence that they had either paid the claimants the said sums or that they were not legally entitled to the claims beyond mere assertions. Defendants' Counsel had challenged the evidence of CW1 and CW3 on ground that they contain contradictions, particularly with regard to paragraphs 9, 10, 12 to 16 of their statements on oath, and paragraphs 9, 11, and 13 of statement of facts. Again, I have perused through the paragraphs under review and do not find any contradiction contained therein, but rather that they complement each other, and I so hold. Then on the testimony of CW2, Defendant's Counsel contended that his evidence amounts to hearsay, having admitted to getting his information from their union. In the record of proceedings of this court of 22nd January 2020, CW2 had admitted under cross-examination as follows. Yes, it is true that it is only bank, myself, and local government that pays. Who knows when salaries are equally paid? Yes, until other colleagues tell me, I may not know when they are paid. I know nothing about case of my other colleagues except what they have informed me, unquote. The above excerpt reveals that as it pertains to the case of other claimants, CW2, who is 13th claimant on record, has no personal knowledge of facts pertaining to them. Hence, any evidence given by the said witness with regard to the case of the other claimants will amount to hearsay, and no probative value shall be given to same. See Kaki and PDP, 2014, 15 NWLR, part 1430, 418 at 419, paragraphs H to A. Flowing from the above, it is my finding that only, Bashima, Please come and check. I think at this stage, at this point, they are not connected. I want to be sure that we are still online. Yes, Gidado, are you with me, please? All right, yes, thank you. I want to be sure. Okay. Flowing from the above, it is my finding that only the first, 13th, and 18th claimants have proved their case on the balance of probability by reason of their written and oral evidence. Also, drawing strength from the authorities relied upon, I further find that particularly the first, 13th, and 18th claimants are entitled to their claims. In view of the success of the main release of the claimants, the alternative release have become overtaken by circumstances, and I so hold. However, the other claimants, having failed to establish their case, their claims are hereby refused. By the above reasoning, the Apex Court had held in the case of Kappa and Delbato, Nigerian PLC and NDIC, 2021, 9 NWLR, part 1780, 1 at 14, paragraphs G to H, that a successful party is entitled to costs, which should not be denied except for good reasons. The court also held in Mekwenye and Emirates Airlines, 2019, LPLR, 46553, Supreme Court, pages 67 to 73, paragraph E, that cost is at the discretion of the court once empowered by its rules. On this, Order 55, Rules 1 to 5 of this court is hereby invoked, and the cost of 100,000 naira only is accordingly awarded in favor of the first, 13th, and 18th claimants. The court hereby orders as follows. A mandatory order is made directing the defendants to forthwith pay first, 13th, and 18th claimants as follows. A, the sum of 1,282,628 naira, being the 45% of their annual basic salary as accommodation allowance for 3 years. B, the sum of 1,350,285 naira only, being the outstanding balance of furniture allowance. C, the sum of 2,850,285 naira only, being 300% of their annual basic salary as severance gratuity due to them as local government legislators in Zamfara State between 25th July 2012 to 24th December 2015, when their tenure expired. D, cost of this action is awarded in the sum of 100,000 naira only. Judgment is hereby entered.
What is my Lord, we are grateful. Thank you for the industry. Yes, my Lord. Thank you.
All right, thank you, Council. Thank you. So for the other matters, we'll stand down for 30 minutes and we'll get back to you. So that we can attend to the Abuja matter. All right, thank you.
Very much.
All right, Council.
So, now, ni ma ba dai hon wallahi ko annan na dai dan fara dauka akwai inda ne mistake nan akwai 1,200,000 sai 1 million
aku ni wannan da dauka da 1,360 na furniture da 2,800 abin ga allowances
cost of action 150 su ne dama wanda aka yi a wani